Hello, members. Welcome back to Agora Legis, the platform of legal minds, where we discuss legal principles and make them clear and easy to understand. And today we are diving into evidence law 1. We shall look at circumstantial evidence, definition, how it applies, what amounts to circumstantial evidence, and the rules governing relevance and admissibility of circumstantial evidence. So without further indulgence, I'm Counsel Ben, and let's jump right in. Well, circumstantial evidence, defined according to Cross and Taper on Evidence, 8th edition on page 22, is defined as any facts, especially evidential facts, from the evidence of which the judge or jury might draw the inference of the existence of a fact in issue. According to the case also of Akbar Hussein Godi versus Uganda, that is criminal appeal number 62 of 2011, the court defined circumstantial evidence to mean evidence in a nature of a series of circumstances that will lead to the inference of the conclusion of guilt when direct evidence is not available. And also, furthermore, in the case of R versus Gilbert and Delay, the court defined circumstantial evidence to mean the evidence, of surrounding circumstances that is able to prove a fact with the accuracy of mathematics. So, members, that is in brief what is the definition of circumstantial evidence. And now we are going to look at the nature of circumstantial evidence. Circumstantial evidence is presumptive in nature. There is nothing that is really proven when we are proving a fact in issue based on circumstantial evidence, but we rely on surrounding circumstance. That is why even it's called circumstantial. We rely on surrounding circumstance to draw the inference of the existence of a fact in issue. That is why we call it presumptive. It's presumptive in nature. It is, secondly, it is the best evidence when we are proving a fact, or when we're proving a commission of a crime. Yeah. I remember even Sir Udo Udoma in the case of Tumuhere versus Uganda. Chief Justice Sir Udo Udoma said that circumstantial evidence remains the best evidence in proving commission of or participation to commission of a crime. So that said, members, we are going now to look at the rules that govern relevance and admissibility of circumstantial evidence. And the first rule is that there should not be any circumstance or any hypothesis or any fact that would weaken or destroy inference of the guilt of the accused. Here, we are seeing that if there is anything that is weakening that inference, because we are not proving a fact directly, but we are relying on surrounding circumstance to say that it is so probable, to infer that it is so probable. So once there is anything that weakens that inference or destroys it, we cannot rely on circumstantial evidence. It is not admissible and relevant in that instance. So we shall rely on it. It has been applied in the case of Uganda versus Dr. Agora Chiyinji. In this case, Dr. Agora Chiyinji was charged with murder of his wife Robina Erina Chiyinji, and he in his defense he successfully pleaded the defense of alibi. Alibi means that the defendant was not at the scene of crime at the time of commission of the offense. I urge you to go and look at the other video on the defense of alibi, well explained, and it will guide you more on that. So he pleaded the defense of alibi to mean that he was not at the scene of crime, and only that weakened and destroyed completely inference to say that he is guilty of anything So that is, members, the first rule. There should not be anything to weaken inference. Second rule is that when prosecution purports to rely only on circumstantial evidence while proving guilt of the accused, the inculpatory facts should be incompatible with the innocence of the accused. What does it mean, members? It means that when the prosecution is bringing its theory, in the prosecution's theory, there should not be anything that would leave room to say that it is possible, yeah, we are saying that he or she is guilty of something, but notwithstanding that, in this other circumstance, it is possible that he might not be the one who committed the crime. So once the inculpatory fact is compatible to some extent with the innocence of the accused, the circumstantial evidence is not admissible as ground for jeopardizing someone. Well, we shall rely on the case of Simoni Musoke versus R. In this case, the defendant or the accused was allegedly the author of a theft of a white Safi car, and the witness said that they saw him or they saw a man with a cap and how do we call these vests of workers in the car, and they also saw him later on in the day wearing the same. So only that when they relied on that, the court, what did the court held? The court held that it is possible that he was not the one, because once the inculpatory fact was to identify the accused in the car at the time where the car was stolen, that was the inculpatory fact. And once it's to some extent it is compatible with the innocence of the accused, because no one really identified him in the car. So what the court held is that the inculpatory fact was compatible with the innocence of the accused, and as such the court could not rely on that evidence to jeopardize him or to convict him of theft. That is, members, the second rule. Going to the third one, the third rule that governs relevance and admissibility of circumstantial evidence states that circumstantial evidence must be narrowly explained to avoid fabrication, to avoid speculation. That is the third rule. Why? Because circumstantial evidence, if not narrowly explained or explained in its depth, someone would create something in his testimony and say, maybe if he saw only someone running, he could say also that I saw him stealing something, then beating someone, then running. So once it's not narrowly explained, it is subject to fabrication and speculation. So this has been applied in the case of Thomas Nkulungira alias Tonku, Uganda versus Thomas Nkulungira alias Tonku, whereby he could not, the prosecution explained narrowly, showing even though it is not direct, but showing brain matters, relying on the evidence that they saw the blood-stained clothes, to show that he was really guilty and he could not give account for those things found in the house, and he wanted to cast doubt on his shamba boy. So that's to show that he was guilty. Going on, we shall look at the fourth rule that governs admissibility of circumstantial evidence, and that is to say that circumstantial evidence must prove a fact completely and must be conclusive. What does it mean? It means that when we are relying on circumstantial evidence, we should cover all the gaps with in the chain of evidence completely, and say that even though we cannot prove this fact directly, we know that due to all the surrounding circumstance, without leaving any doubt, without leaving any gap, the accused is guilty of so and so. So that is to say that the circumstantial evidence should prove a fact completely and should be conclusive. So that said, members, we have seen the law that governs circumstantial evidence in the Ugandan legal framework. I urge you to share, like, subscribe to the channel. That is the only way we could support this initiative. I also urge you to get in touch with our tutors. The contacts are just there down in the description. Hit the subscription button, and thank you for watching. See you in the next video.